Just going to start. So good evening, everyone. Welcome to the semi-finals of Indian Debating League. I am Devika Khanna and I will be moderating this round. So I'll quickly introduce you to the adjudicator for the day, and she is none other than Himanshi Wadhwa from LSR. Himanshi ma'am is a renowned name in the international debating circuits as well as in India. More than that, we have her as she tops the best adjudicating consistently in major circuits like UIDO BPD 2021, Uhuru World BPD 2022, and she has also been the invited adjudicator and grand final chair of ICFAI APD 2022. And yes, dear debater, she has recently won some of the prestigious tournaments like grand finalist of the Clash of Middle Earth BPD 2021 and Link-Based Debating Championship BPD 2022. Thank you so much for joining in, Himanshi ma'am. All right, so today we have teams Haryana and Gujarat from the grade category 10 to 12th. The motion for this round is, presuming that the technology exists and given the delay in judicial proceedings due to massive backlogs, this house will use the technology which give insights into all of a person's mental activities in major crimes. Hopping on to the explanation of the topic and understanding why it is an important motion. So only a few months ago, the Chief Justice of India announced that there has been a backlog of 40 million cases in the lower courts of India. We have only 20 judges per million people as of now. If this technology exists, investigating crimes will become less time consuming and thereby more efficient judicial operations will come about. Or is it? Question. So each speech is going to be 7 minutes long and the reply speech is going to be for 3 minutes. Speakers may ask POI. No POIs in the first and the last minute of the speech can be asked. POI preference could be verbal or in chat, and that will be indicated by the speaker before he or she begins with the speech. Quickly, I would just iterate few ground rules. So I would request all the debaters to please turn on their camera when you're delivering your speeches, because you will be considered on the manner method. For timekeeping, the adjudicator is going to iterate the rules, how she is going to keep up with the time. Also, you will have 15 seconds to wrap up your argument. It is a request to do not exceed the time limit, and the time is going to be presented to you, and that would be given a confirmation by the ma'am before she starts with the speeches. So on that note, I would now like to hand over the room to Himanshi ma'am. Himanshi ma'am, please take up the room. All the very best debaters.
Hi, everybody. Thanks for having me here. I'll just share my screen with the timer. Please let me know if that's visible. Can you see the timer on my screen?
Yeah.
Yes, ma'am.
Great. So without any further ado, I invite the first speaker from side government, the Prime Minister, to start their case. Here.
Am I audible?
Yes, you're audible.
Hello? Am I audible?
Yes, you're audible.
Yeah, cool. So I'll be beginning my speech in 3, 2, 1. December 16, 2012. A 23-year-old woman was brutally assaulted and raped in a moving bus. It took 8 years to get justice. 2014. Pallavi Purkyastra's murder case. It took almost 2 years for justice to come around. While murderers, rapists, and those who have committed the worst humanitarian atrocities roam without punishment, we say that the judiciary has judiciously failed us. That is why we're very proud to propose. What is our stance in this debate? Firstly, what are major crimes? Major crimes are murder cases, mass murders, brutal gang rapes, terrorism, human trafficking, drug crimes, etc., which essentially inflict great pain towards other members of the community and will not allow these assaulters to roam free. B, what does this insight in mental activities actually looks like? It looks like ideas, emotions, motives, feelings, actions, etc. at the time of the crime, which essentially tells us A, if they did it or not, B, what were their motives, and C, what were their mental health and feelings. And you know everything about the crime from the perspective of the accused. More importantly, the technology can be only used in major crimes and only against the accused. It cannot be used against the victim or the witness, and the results would be kept fairly private amongst the major entities of the judicial system. The media and the public do not have access to the result of these. And more importantly, this technology will be used only when the criminal judiciary system deems that this major case is actually in need of the technology, and this allowance of the technology can only be allowed by the independent judiciary, not by the government or by independent private institution. What is our case split here? 3 points. Firstly, about efficiency and effectiveness. Secondly, about principle of justice. And thirdly, how it reduces overall crime. On to the first argument about how both efficiency and effectiveness of judicial system will be benefited. First, efficiency. Now, judicial system is an inherently slow process. This looks like 4 million cases in general pending, and 76% of prisoners are under trial. Why is this so? Firstly, it's an essentially long process because it involves witnesses, accused, victims, etc. And in these major cases involve a comprehensive process, years of dates upon days, investigations, need to have more proof. And that is why it is delayed, because we need to gather evidence from all external sources. What impact does it have? A, it has an impact on the judicial system, since it is not able to fulfill its role to be efficient. Secondly, it has an impact on the victims who do not get justice, and these victims are the most vulnerable minorities who do not actually have enough funds to spend in these long court trials and have actual the economical capabilities to go in these 10 years and 5 years and 3 years that it takes and keep on revisiting the courts, and it takes a lot of their time and effort which these vulnerable victims are not able to provide. More importantly, the innocent people that are actually accused, they're subject to so much humiliation, social, economical subject, etc., which inherently degrades our judicial system. How do we solve this problem? Now, what we do is we reduce the process duration, because you do not need to actually gather so many evidences and witness to prove beyond reasonable doubt that the accused is guilty, because you'll automatically know whether the accused has committed the crime or not. It leads to better judicial system, and victims will feel greater comfortable to be actually be able to report these circumstances, because it leads to because they have guaranteed justice. It leads to more comprehensive and faster comprehensive as well. Secondly, about effectiveness. What is the problem then now? Now, here's the thing: investigation in judicial system is inherently flawed. People investigating might be biased, they might be racist, casteist, institutionalized racism, etc. For example, a white man is given the benefit of doubt that he may or may not have committed the crime, but a black man is given subjugated to like, who is definitely committed the crime, and these biases in the investigators has a great impact. Secondly, the public opinion against the victims or the accused also has great influence in the investigation. Thirdly, note that the rape victims or the victims in general are very vulnerable. They're minorities, they're vulnerable with less resources and power, and they're more likely to lose against these rich criminals who are impossible to actually hold guilty, because they often very nicely cover up their crimes and they abuse their power. And even more emphasizing on that these victims are subject to great humiliation, because the judicial process is inherently very degrading. Example, in rape cases, when a person who is just being raped, who's in great PTSD, emotional vulnerability, being asked, oh, because what you were wearing, oh, that was why you were raped, this cross questioning, when a person who's just being raped, who's in great emotional vulnerability, is poked, prodded, and their question and character is being questioned here, it leads to them to actually be less likely to pursue these cases, as we've already seen so many rape cases refuse to actually come out. um, and and that is why, how do we solve this? Firstly, we reduce focus away from victims and poking them and prodding them. The focus shifts to the criminal, wherein we're able to actually tell whether they have committed the crime or not. It solves the problem of a biased investigation, because you can clearly tell who the accused is and their motives, etc. And secondly, because victims, it gives them the security of quick and effective justice, and they're more likely to actually pursue these cases. And thirdly, it helps the innocent people who are accused, because flawed investigation and biases might have put them in a position and they can quickly and effectively come out of it. Now, And now, second argument about principle of justice. There are three principles of justice: A, retribution; B, rehabilitation; and C, deterrence. A, retribution. Now, the state has a greatest obligation to the victims, right? Now, let's talk about right to privacy. Firstly, right to privacy is not absolute, because in these major cases, often these vulnerable victims are prodded and pruded, even the accusers are prodded and pruded. So there's a very blurry line between privacy. And secondly, we've already mentioned in our models how the results are kept private. But thirdly, even in our worst case, even if the right to privacy is being inferred, the state has the greatest obligation to bring justice to the victims. So we're ready to make that trade-off of the right to privacy. Now, secondly, about rehabilitation. Now, criminals are also better off in our side of the world. Why? For the motives, when we're able to actually know the motives, reasons, and mental health, we can properly actually understand the criminal. This allows, for example, in hit and run trials, murder cases, a murder case where there was a genuine mistake and worry, we're able to understand them. We're able to actually have a better, more suitable punishment for them, and take all factors considered into punishment. And morely, we're able to, when we're able to understand their motives and mental health, we're able to counsel them better in rehabilitation, which to the point, and which leads to lesser crime. And that is why the world is way better off on our side of the world. Thank you. So proud to propose.
I thank the speaker for their fine speech, inviting the leader of opposition to start their case. Here.
Am I audible?
Yes, you're audible and visible.
Okay, so I'll start in 3, 2, 1. In long term, artificial intelligence and automation are going to be taking are so much. Sorry. In long term, artificial intelligence and automation are going to be taking over so much of what gives a human feeling of purpose and being a human. Good evening, dear adjudicator. So today, the motion states that this house will use the technology which gives insight into inside all of a person's mental activity in major crimes. Basically, it implies that we will use a certain computer, a computer program, and artificial intelligence, which will invade a person's mind, a person's very soul, to get details of their perspective and knowing of a certain accusation of an event. Just the concept of allowing something to get access to a person's very self and their mind is dangerous and totally a breach of their privacy. Getting computers of their privacy and getting as the proposition proposed of getting this as the proposition proposed of getting this computers into a judiciary system. I would like to ask them, like, we are in India, and I completely understand that we have a lot of backlog of cases and very less judges. Our judiciary system is slow, but still even now, even if someone has a problem, if someone has a conflict, they still trust and believe the judiciary system and that it will help them and help them get justice. And our people who still can't trust uh, like computers like EVMs. A lot of people still think that they are rigged, that they are altered, they are hacked. In a country where people can't even trust on EVMs, how can you expect to trust them on judiciary system, which will work on these AIs, which will work on a computer? Just imagine, how will a person feel when they carry on? Can I ask the PY?
Thinking that a judge still makes a decision at the end of the day. At that point, why are people disincentivized to trust the judicial system?
Because you are implementing a computer system, and people do and in India, people do not trust a computer. They do not trust technology. And carrying on with my speech, this will just obliterate a trust on the judiciary system of our people. Our people need to relate, that people need to connect to the judge. They should feel like the judicial system, the judge will help them get the justice. And the people of India, I don't think that they will, I strongly believe that they won't trust a computer as much as they will trust a judge. And this act and the problem of the problem of the backlogs cases and the problem of these all cases can be solved by alternative methods and processes that I will tell you just in a minute. And another thing I want to tell it, in India, how can you tell a accused, how can you tell the family of an accused that, hey, your fate, it depends on a piece of metal that just transmits and processes zeros and ones. You can't tell them that your fate depends on a set of zeros and ones going through a metal sheet and a piece of metal. I understand that our judiciary system may be slow. It may be a lot of money, financially straining, but there are alternative methods. First, it's a very basic thing: hire more judges. In a country like India, where unemployment is so high, if we hire more judges, it would make more room for even for lawyers to pursue their careers, and the judiciary system will get a lot faster. And you can't really trust a machine if it reads a person's mind. A machine will show the emotions of the accused. What about the
POI.
reason? I'll take it later. It will be answered later. What if a normal person who had a fight with her or his spouse was walking out on someone with a mind of a devil trapped in a crime? Will the machine still tell that though he was angry, but he was involved in a crime? It will only show the person's anger. I'll answer that later. Are we ready to risk an innocent person of life, an innocent person life on a machine? And the alternative methods that we have on them, the alternative method I would like to propose is the ADR system, alternative dispute resolution. ADR mechanism, dispute resolution, is a non-adversary, i.e. working together cooperatively to reach a resolution for everyone. It will be really great for our judiciary system, as it would reduce the burden of our judiciary system and our courts. It provides the opportunity to expand the pie through creative collaboration, bargaining, and fulfill the interest of everybody demands. The mechanisms in ADR, the first mechanism that we have is arbitration. The dispute submitted to arbitral tribunal, which makes a decision on the dispute mostly binding on the part, which is mostly of the binding parties. It is less formal than a trial, and rule evidence mostly relaxed. Generally, there is no appeal of an arbitrated decision. Conciliation, a binding procedure in which an impartial third party, which is on a mutual satisfaction and agreed by both the parties, is bought in. It is less formal, and it settles and makes a decisions which is agreeable by all. Mediation, basically it brings a mediator. He helps to settle the dispute, and all this is happens on privacies. All the things that happens are confidential. There are a lot of advantages to this, and I would like to rest my speech here. Thank you.
I thank the speaker for their fine speech, inviting the Deputy Prime Minister here.
Yes, before we start, I'll take POIs verbally, so just unmute yourself. But after a point, I say that I'm not taking POIs, then stop. And yeah, so I'll be starting my speech in 3, 2, 1. Good evening to the House at large today. As a DPM in today's debate, I shall be doing 3 things in my speech. Firstly, rebutting the previous speaker. Secondly, reconstructing our case. And thirdly, giving out the third constructive. Now let's just come to the rebuttals. Today, the first speaker of the opposition has told us very ideal things. They've told us about how they started off, the person started off by saying that technology is going to replace human emotion. But sir, we were talking about the judicial system. Emotion is exactly what we don't want in that system. What we want are accurate results. What we want is justice served to the people who deserve it, right? We want the victims to feel pleased with the this thing, justice which is being ruled out. And therefore I don't think this is a very good statement to make that technology threatens the human emotions, because emotions don't play a major part in the judicial system, and they shouldn't either, right? Secondly, the opposition told us today that people, or as the opposition has done, is that they've centralized the whole debate to India. But I would like to go away from that and say this debate is definitely about the whole world. It's not just about India. But let's just talk about the opposition's case. They told us that the Indian people don't test the technology. Now, we in a POI told you that the last and the final decision that is ruled out by a judge who is a human, who's not technology. The opposition has tried to downplay what technology is, even though there was a whole information slide provided about this technology being credible enough to be able to analyze the human emotions. We still are going to take that case and say, okay, so if this technology is not able to identify the emotions, let's just say the judge is actually making the final decision, right? Thirdly, we talk a lot about trust, right? The whole concept of trust came up a lot in the opposition's case. Let's just talk about how the opposition's case, the judicial system is rigged by third parties, by corruptions, by people who are in higher classes, who have more money to bribe the judge, right? So if people trusted the system, why are there still cases out there who don't want to take their case to the system? Because they don't trust them. So I think that's not an argument which is fair, right? Technology is definitely reliable. That was even in the information slides, and that's going to be established again. And thirdly, the counterfactual of a ADR is faulty, because even in that, the effectiveness is still going to be very low. Even if you divide the case into half and half, third party still exists, corruption still exists, and bribery still exists. So now let's just come to the
I have a POI.
No, I'll take that later. Now let's just come to the two arguments that I'm going to present. That we've presented so far. Firstly, the argument about how overall effectiveness and efficiency of a justice system is increased by creating a much better world for our stakeholders. Due to the inherently slow and tiring procedures, which are very prone to misunderstandings or bribery, many people don't even have the courage to stand up if they are victims to certain crimes. My first speaker told us the statistics for this, and therefore we proved to you that a world with technology increases the efficiency and effectiveness. Secondly, we tell you about how this policy improves the judicial system in two major ways. Panel, please note this, because this is a direct rebuttal to anything that the opposition have said today. House, we tell you that the justice system in the status quo today is not only inaccurate, but also in many cases biased by third parties. We say this with full evidence of past instances that we all know of, as well as the major point of one judge singularly handling many cases. That sets context for our first argument of the right to a fair judicial system. In this, we tell you that in our world where technology helping serve justice, there's likely to be a higher chance of the decision being made accurate, only guilty people being charged, and external factors of emotions not affecting the decisions made. Yes, I'll take that POI now. Go ahead.
Yeah, the ADR system, the parties in an ADR system are mutually consented to be the mediator for the trial or the conflict.
I can only give you 15 seconds. We've already told you that effectiveness does not increase, and I'm going to speak about that later in the argument, so listen carefully, I guess. Now, before the opposition rebuts this, let me analyze the worst case scenario of our side and the best of theirs. In our worst case scenario, we're likely to invade the right of privacy, right? But as established before, in our model, this right is not absolute, and the state has a higher obligation to the victims than to the crime committers. In the opposition's best case scenario, we still see that the decisions made by the justice system will always be prone to being inaccurate, as there's always going to be the risk of human error. In this argument, we also tell you about how the justice system can very often be biased against minority, abused by power, and bribed by higher cases, as established many times before. This brings me to the third argument, which is the very reduction of crime. Panel, I think it's been established well enough that our side provides an effective system and one that's fair. We have repeatedly established how the results of such a policy in the status quo will create a prosperous society. But let's just break this down into smaller steps of what exactly helps us bring these results. What the proposition presents today is not only technology into the justice system, but a whole deterrence mechanism that lowers the crime rate drastically. Now, you may question how I say this so confidently, but well, let me tell you. In the status quo or the opposition's world, a majority, and I mean a vast majority of crimes that are committed are due to the lack of fear of getting caught. It's a basic concept. We don't do bad things because someone will scold us about this. But are we likely to commit these crimes if we know that we're potentially not going to get scolded? Well, yes, we are. So now that our side will, now that on our side, people will know that in a courtroom with technological help, it is likely to be figured out whether you're guilty or not. You're likely not to commit a crime. Even in the worst case scenario on our side, there's likely to the criminals of such crimes are likely to question themselves many times before committing actions that end them up in a courtroom. Secondly, we tell you about we tell you about being able to in depth understand how exactly a criminal's brain works. Panel, notice this is something that scientists before weren't able to do accurately, which is in the status quo, right? So we tell you that we're actually able to look into what made that person commit a crime. So we are able to connect a line to the common cause. Whether this common cause be policies that were implemented, shortage that left to no other choice, it will be identified on our side, and this would help the government to work on things that incline people to commit these crimes as a last resort. In simple words, we will be able to target the cause of crime. Through this constructed, we even look at people who have already committed the crime that may have not been a direct or innocent case, like something like a hit and run case, or something which is a line between innocent and guilty. Now that we know how their mind would work in a situation, we would have the upper hand of we would have the leverage of improving the rehabilitation counseling of such people. Right now, coming back to the POI, you asked, yeah, why is the ADR system faulty? Well, we told you, okay, so you divide the cases and people mutually agree. But the thing is, we even told you about human errors, right? We told you that we need accurate results, and that's exactly what you're not able to bring to us. This brings me to the conclusion. Panel, we've told you how this policy is not a want policy, but a need policy, by telling you that it will bring real change into the status quo, and it will 100% improve the justice system. Further, we even look into the opposition's case and prove to you that how even in front of their best case, our worst case is still likely to be more beneficial. Therefore, we believe that this house would most definitely use the technology which gives insight into all of a person's mental activities in major crimes. Thank you.
I thank the speaker for their fine speech, inviting the deputy leader of opposition. Here.
Yes. I'll start in 3, 2, 1. Greetings to everyone. I'm Nandini, the deputy leader of the opposition. The motion for today's debate proposes the use of technology for tracking the mental activities of criminals, also known as brain fingerprinting. We believe that the use of such technology is neither safe nor feasible. If we are to judge what is going on in a person's mind while they are committing a crime, it is a gross violation of a person's right to freedom of thinking. People have a right to privacy, a right to not incriminate themselves, and a right to freedom of thought. Brain fingerprinting threatens all three. The computer and the hundreds of computers will be looking through the thoughts of a person. And now the person will not even be able to think freely in the fear of his thoughts being detected by technology and law enforcers. And no one has the right to anyone's thoughts, be it the judicial or the public. Now, replying to the second speaker of proposition, they said that the final decision will be taken by the judge, who is a human. So what is the point of employing technology in law enforcement techniques when at the end of the day, you're depending upon a human being for the decision? What is the use of taking the help of technology at all? Continuing with our argument, brain fingerprinting cannot be used for crime resolution because this technique is not 100% true in every case, as it only detects information in the brain of a person. It may be that an innocent person may know about the crime as a third person or listener, or perhaps that he may be present at the crime scene. The hints and evidences shown by the operators of technology might ring a bell in their mind. This would lead to the unnecessary punishment of an innocent person who was just aware of the crime, not involved in it. In this way, all the witnesses will show a familiar response to the crime scenes, but that does not mean that all of them are to blame, since so many people would be recognized as the suspects, even when they're completely innocent. Confusion will still prevail and a solid verdict won't be released. Another drawback of using computer technology in law enforcement and brain fingerprinting is that digital or electronic data and evidence obtained during investigations may easily be modified, deleted, or lost. The safety of such information is always under threat and the system is prone to hacking. Moreover, those people who are biased towards a particular decision might even modify the information and present it in such a way that favors a particular side over the other one, thus leading to a biased decision which can be unfair and unjust at times. And of course, the computer technology might be reliable and accurate, but no assurance of whether our data will not be lost or mistakenly deleted by the handlers of information. This fact makes the admissibility of such evidence in court to be contested, thus slowing down the prosecution of crimes. Moreover, computer technology is not only expensive but also requires highly skilled officers to use and analyze the data while also complying with the legal standards for forensic analysis, handling, and storage of such
Why?
computer-generated evidence. Yes, go ahead.
Given that we told you in first that this technology literally has like almost a video camera type effect where it like literally records memory from memory, how then is there going to be like an innocent person being sent to jail?
See, it's not just the accused person who is aware of the crime. There are always witnesses, those who are around the crime and have watched it happen in front of them. So even they are aware of that and they have that pictures and scenes fixed in their mind. So that will also be shown in the displayed in the computers and technology. So even they would be suspected as the wrongdoers. Continuing with my speech, building such technologies, keeping them up to date, and repairing them whenever required will cost large amounts of money and increase the maintenance costs. Moreover, the use of such a complex and extensive technology will require highly skilled technicians and engineers, and such a job cannot be handled by any simple engineer. Employing such tech experts and people who are proficient in these skills is again not an easy task, and surely they will be demanding high salaries and incentives, adding to the already hefty costs. This is because law enforcement agencies will need to employ skilled personnel to facilitate the use of such technology. Now, the hefty costs will have another serious consequence. As the technology is costly, not all the people can use it because the majority of the population is not as rich as to be able to utilize that, so they cannot afford it. Now, since only a small part of the ultra rich will be able to use this technology of decision making, it will again lead to biased decisions, as some decisions were made with the assistance of technology, while others were purely based on human discretion. Yes, I will take that.
Given that the government is literally using this is like it's happening through the judicial system, it doesn't matter whether you're rich or poor, like in all major crimes, it's likely to be used.
But you have got to pay some amount for being able to use that technology and service. And of course, not all people are rich enough to pay that amount. And since judicial system is not as expensive as using technology, it is better to employ that, the human-based judicial system. So since most of the criminals do not belong to ultra-rich backgrounds, how do you expect them to afford and utilize such services? And those who can afford it are not frequent criminals. The solution that we propose is ADR, Alternative Dispute Resolution. It refers to the different ways people can resolve disputes without a trial. Common ADR processes include mediation, arbitration, and neutral evaluation, as explained by our first speaker. These processes are generally confidential, less formal, and less stressful than the traditional court proceedings. Moreover, ADR often saves money and speeds settlement. So, to sum up, I would like to state that the use of technology is good and convenient, but we cannot employ technology in every aspect. Judiciary should be purely human-based. Certain jobs and decisions should be left to humans only. And that is why we oppose the motion. Thank you.
I thank the speaker for their fine speech, inviting the government whip. Here.
Just a minute. Sorry for my background. I had to change last minute. Just a minute. I will just set up my own timer. I'll be starting my speech in 3, 2, 1. Symmetrical claims from side opposition. One, that you can modify data. I think this actually happens more on your side of the house when it's so much easier to actually tamper with evidence, because there's so much evidence and the rich people can actually tamper with evidence. But two, like this is just likely to happen on either side of the house. I don't see why this is exclusive. Secondly, that there will be mistakes. Well, firstly, just know like these guys are trained, trained professionals. I literally don't see why they're likely to commit these mistakes. These are like serious crimes. But secondly, even if that is the case, even in status quo in the normal judicial system, mistakes happen. I don't see again why that's exclusive. 3, in the first piece, they tell us, AI is really bad. It interferes with the right to thought. I want to know that AI is already likely to grow, right? I don't see why using it in the judicial system is likely the tipping point. So even if we accept that this AI is really bad, it goes against like human instinct and blah. I don't see why this is the tipping point. And then secondly, that like this technology already exists, right? Presumably this technology to like see what happens in one's mind already exists, which means that it's anyway likely to be used in like other spheres. What we do on our side of the house in our model is we actually control its uses, so we think we're way better. Fourthly, that it's costly. One, sure, but like extensive investigation is even more expensive, right? When literally hours and hours have to be used in court because the system is so inefficient, we think that's far more expensive than like using this technology. But even if it is expensive, the government sponsors it. I don't see where the point about it's not going to be affordable for the poor ever comes in, right? Because literally the government is sponsoring this. But even if that was the case, anyway, the poor are like unlikely to be able to afford like courts and stuff. We actually make it easier at the point at which you don't have to depend on lawyers and all that kind of stuff. 3 claims then from side opposition that we get. Firstly, on trust. Secondly, on privacy. Thirdly, on like the technology. Right?
POI.
No, thank you. That the extent of the rebuttal to our entire 3 arguments, which are never responded to otherwise, is that this technology is not perfect. It's going to implement innocent people without ever telling us why. Right? I just want to make it very clear that this technology is not only telling us about the emotion, like we told you from first. Right? We literally tell you that it's like a kind of like a memory thing. We're able to access the memories of that individual. We're able to literally see what his thoughts were, what their thoughts were, what actions they were committing, right? I don't see why like this technology is not useful. Secondly, they tell us, you're going to punish the innocent. I think there are always like circumstances when the judge can say, hey, even though this is seen there, I think there's enough proof to say that this guy was a witness and wasn't doing anything wrong, so I'm going to acquit him, right? I don't see why this technology is the be all and end all. There's always a judge. Secondly, on the second claim, what do they tell us? They tell us, people are going to think it's rigged, then thus they're not going to trust it. This is the extent of the argumentation. Several points of rebuttal. Firstly, I think at the point where this technology become normalized with like the mass usage of it in judicial system is likely to be trusted by people, because like anything is likely to be trusted by people when it's used often. 2, I want to know that judges still make the decision, right? At the end of the day, the judge is still making the decision. So all their argument about our human interaction just goes out of the water at the point where there's still a judge, right? And I just want to know that their responses, they say that then what is the use of this technology if this judge is still making the decision? Is to aid the judge in making that decision, because it's far harder for a judge to actually use his bias to actually be biased at the point where there's literally this technology which is saying, hey, this person committed a crime. Thirdly, I think people anyway don't trust the system, right? Because of things like corruption, because of like the general distrust to the government, which Indians have. I think this is symmetrical at best for them, right? But I'm actually going to flip this and say you get more trust on our side of the house at the point at which you know that this bias won't play against you, at the point at which you know that there's going to be less corruption, because this is slightly objective metric, right? But fifthly, even in the best case, even if people don't trust the system at all, victims are still likely to take cases to court, right? Because the need to revenge overrides any of these concerns, right? Note that we told you that the point at which people are unlikely to approach the court is the point at which they're unlikely to win, right? Because of things like bias, which means that like even in an absolute worst case, we still get people going to court, and like we don't really care about whether murderers and rapists don't trust the system, right? It's like literally legally binding. I don't see why that's the metric in this debate. I'll take a POI. All right, seeing none. What this then means is that the first claim has fallen. Secondly, what did they tell? They tell us some weird counterfactual on like ADR and like, we can hire more judges. One, we can hire more judges on our side of that. It's just really costly. You need like 10 million judges to solve the problem. 2, on ADR, I think that they forget that this only happens for major crimes, right? We're not going to like implement this technology for like petty thefts, etc. We're going to literally implement it for crimes such as murder, such as rape, right? I don't think you're going to like be able to come up to a resolution like a nice resolution at the point at which I, as the father of like a rape victim, I'm not going to be like, I'm not willing to like really interact with the person who actually raped my daughter, right? I just don't see why this system works. But then secondly, it's just not binding, right? I just don't think it's legally binding. Again, it's for major crimes. These rapists aren't likely to like just give themselves in. But thirdly, if it is indeed so helpful, then we're happy to implement this policy for like minor cases. But we think for the major cases, our policy is required. Lastly, I think this, like, they literally just tell us one line, it goes against the right to privacy. Several points of analysis. Firstly, why the right to privacy isn't violated. Firstly, I just want to note it's not
A POI.
absolute, but then no, thank you. That it's just symmetrical anyways, right? Because anyway, the court system is going to probe into the life of the victim, which means that anyway, this right to privacy is violated. I'm actually going to flip this and say we actually get more privacy for literally everybody else except that suspect, right? Because we don't go poking into the victims, right? We don't go poking into like the suspect's family life. We simply poke into the suspect, which means we actually get more net privacy. But then thirdly, we told you results are kept private. Fourthly, we're just looking at like 1 or 2 days, like whatever time period of the victim's mind. We're not like looking to his entire life story. Secondly, even if we are violating the right to privacy, we're okay to weigh this up. We get no response to this. Why? One, because victims are the most vulnerable. The suspects are likely guilty, which means they don't have access to the same rights that other citizens have. But two, numerically, we benefit a lot more people because of the deterrence mechanism, which means that crimes as a whole are reduced, right? Weigh that off against a few criminals having their right of privacy violated. Panel, they haven't responded to any of our three arguments. Firstly, on efficiency. Secondly, on effectiveness. Thirdly, on our principle on the right to justice. And then fourthly, our second speaker argument on why it reduces crime. I just wanted to weigh that off against the little that they have. So even at the absolute best, we still win, right? But then lastly, I just want to say, we think utility is the best metric, right? Because deontology is something that is external to us, right? You're just asserting things like you should not, right? Without giving any reasoning to it. Also, note that utilitarianism is arithmetic. You're literally calculating the total utility of an action, how many people benefit from it, which means that it's likely to be a lot more objective, which means even if you think we lose this clash, we still win on the basis of utility. We think that's the most important metric in this debate. So proud to propose.
I thank the speaker for their fine speech, inviting opposition with here.
I'll start my speech in 3, 2, 1. Without any further ado, I would love to jot down some of the points which were stated by my teammates. Also, I'll answer a few of the questions by the proposition. Introducing a technology which can read the mental state of a person who is involved in a major crime. He or she can be a witness or a criminal, him or herself. It will violate, first of all, Article 9, which states which is right to thoughts, and Article 21, right to privacy, as one has his or her own experience or opinion about the incident or the major crime case. Misuse of technology can also be done. In a case of a judicial system, technology is constantly changing. There can be a case where a law which is not currently, or shall I say, which was passed earlier but is not currently used or is in active state. If the computer is not been updated, or if there is some sort of an error in the computer, it can show and it can use article which was earlier used. The other major fact, or I'll say a major concern, is about the hacking, as the data can be easily disturbed, modified. Yeah, I'll take that.
Can't the evidence that is manually taken be tampered as well? Given that it takes so much time and
It can be, but if we're talking about hacking, it is much more easier, don't you think? You're sitting in your house and you can just tamper the data if you have the codes or the algorithm. I guess I've answered that question. I'll move ahead. The Law and Justice Ministry sets a budget for the judicial system, which is approximately around 4,000 crore. And if the technology is advanced or the AI system is introduced in this kind of system, judicial system, this will of course increase the budget, and the taxpayers or shall I say the civilians will be burdened with more tax. This was one of the questions which was asked by the proposition. ADR method, it stands for alternative dispute resolution. I'll I'll agree it is very tough to perform this kind of methods on a big scale, but on a small scale, in a less informal way, less formal way, it can be done in a traditional court proceedings because it is a neutral. What can I say? Neutral evaluation. Yeah, please go ahead.
Think I, as the father of a rape of like my daughter who has been raped, is likely to come up, is likely to like agree with literally the rapist.
Agree with the rapist? See, I'll say there's a neutral evaluation. I'll again say, the police will, I guess, or the authorities will, of course, look into both the cases, and in these kind of cases, mostly evaluation are done on a higher basis as well. So there is no need of some sort of AI technology, even though it's time consuming, but it can be used. In the end, I would, I guess, end my speech by saying that one of the major concerns, or rather, I say a thought of people is even today, people they don't trust EVMs or crypto. Do you seriously think they'll trust machineries in for judicial purposes? Whenever there is a conflict, wherever there are people, two parties in a conflict, and it's tough for them to get out of that, you'll never find someone saying that we'll see you in a computerized lab where we'll be in front of an AI technology which will evaluate us. There's a sense of trust, or shall I say, um, kind of thing here where people think that justice can only be provided by a court, rather or not machineries or AI situations or AI based technology. Thanks a lot. I'll end my speech.
I thank the speaker for their fine speech, inviting reply speaker from side opposition whenever you're ready.
Yeah, so I'll go in 3, 2, 1. Am I audible? Yeah. So as we have stated and mentioned numerous times, the ADR system, it is an alternative method. It will reduce the burdens that the judicial system already has. It will it will solve the cases before it will reach the judicial system, reach the courts, which will lower their pressure. And it will also help that if and in India, even we have outlawed jury. So I don't think that it's great to, so I don't think we will ever again get a second party or a aid to the judge, because we have even outlawed jury. So the implementation of an AI or a computer seems quite impossible for nation. And the second thing I want is, you can't really ask someone, you can't really ask someone or tell someone that, hey, your life is dependent on a computer, on a machine, which, as stated by the proposition, runs arithmetic problems. Because a case, because a case is, I don't think, something that you can solve with maths. It has a lot of other variables. It has a lot of other things in it. I really don't think that a computer can actually help in a case where as human memories are also subjective to their emotions. They Studies have also showed that memories also tend to change according to the person's perspective and mindset. So I guess I here rest my reply speech. Thank you.
I thank the speaker for their fine reply, inviting the government reply speaker. Here.
Hi, am I audible?
Yes, you're audible.
Also, I just wanted to confirm, how long is the reply speech?
3 minutes.
All right, thank you. I'll begin my speech in 3, 2, 1. Panel. The first speaker comes up here of opposition and talks about trust. The second speaker comes up and talks about faulty technology. And the third speaker comes up and talk about how hacking in a government controlled secure system is far more easier than tampering of evidence. And this conflicted case can be seen in the vagueness of the reply speech, and that is why we've clearly won this debate. And we can also clear that they did not engage with any of our substantives. Two questions then in this debate. Firstly, who takes this debate principally? And secondly, who takes this debate pragmatically? Firstly, on the principle level, we tell you that the state has such great obligation to the victims. Their reply was right to privacy, which has been countered in the very first speech itself. When firstly we tell you that it's not absolute, right? This right to privacy, especially in major rape cases and murder cases, when victims their lives are prodded and questioned, there's a very blurry line in these major cases to actually privacy, right? Secondly, we tell you that the results of these would be highly private and would not be released public or in media. And thirdly, even if we say that yes, the right to privacy is to a certain extent in our worst case inferred, we say we're ready to make that trade-off because the obligation of the state to the victims is far more higher than the accused. And that is why on the principle level itself, we take the debate. Now, on the pragmatic level, what do we come up here and tell you about each stakeholder? Firstly, we tell you about the victims, how it's going to help the victims. Firstly, it's going to increase efficiency since you go and like actually collect evidence, it would reduce that time period, and that is why it's going to be far more efficient. It's going to be far more effective since now not a long time can be not a long time will be taken, and now you can guarantee, and it will be in a dignified manner where victims' life are not being questioned in such a vulnerable state. And it increases trust on the judicial system rather than when they come up here and tell us about how it decreases trust in the judicial system, when it rather increases trust. And at the same time, the question, the thing that the results are still being at the end of the day taken by a judge. Then we tell you about how criminals are also helped in terms of rehabilitation and how it's overall better world since the data on mind is also collected. What data come up here and tell us about how tampered technology? Firstly, the four major key things that they talk about. Firstly, emotions. They tell us that only the emotions can be seen. We told you in our model itself that it's a camera lens where all mental activities and memory can be seen. So it's basically very reliable. Secondly, they talked about money, how maintenance and affordability is a question. Firstly, government sponsors these things, and since it takes less time, it's far more likely less money taking away. And they talked about lastly about manipulation of technology, which is firstly not exclusive, and hacking in a government controlled machine is not easier. And they're counterfactual about ADR in major crimes. I don't think settlement in murder cases are really efficient, and that is why we've clearly won this debate. Thank you.
I thank the speaker for their fine reply speech. With this, we come to the end of the debate. I once again thank all the speakers for their wonderful speeches. I'll just take some minutes to prepare the verdict, fill the ballots, and then I'll be right back.
Good evening, everyone. I know everyone is really excited and nervous to know what the final verdict is. So till the time ma'am is deciding and deliberating on the result, why don't you guys tell me how your experience was, what all you were feeling while you were debating? Were you nervous? Were you excited? Just go ahead, anyone.
I can start. I think. Do you want me to turn my camera on?
Yes, please. Thank you so much.
Yeah, so basically, I think it was a very good debate topic because I think it's a very real issue that's faced in at least like in India and everywhere else also, I'm pretty sure. So I think debating the topic made me feel like some kind of a real judge of it. So it was an interesting debate, at least for me.
That's lovely to hear. And, it's always interesting to challenge yourself and, go in depth to the motion you have got or maybe the topic you're discussing at. Thank you so much, Anvi, for sharing your experience. Anyone else who wish to speak about their experiences, the floor is open for you.
Yeah, I think it was a great
I felt
experience
that
from
the
like
question was certainly challenging and it required extensive research. But still, it was a lovely debate. We really enjoyed that.
Great. I do hear a lot of people sharing the experience. I'm collecting that was Nandini, right? All right. I also heard one more person speaking in between. You can go
yeah.
ahead.
What I was saying, I thought it was a really good experience, like right from selections to now the like then the group matches, then semis, and hopefully finals. But that's it.
Yeah, I think that we just have to give some time to ma'am to deliberate and give the final verdict. So I think we are all going to keep the fingers crossed and may the best team win. All the best, guys.
Devika, is it okay if I ask a quick
Thank you,
question,
ma'am.
Aro?
Yes, ma'am. Yes, ma'am. Sure.
Aro, can you please explain your DP to me? It's just making me very curious. Are you there?
Yeah, I am here. I'm sorry, I forgot to change it before the
No,
debate.
I'm just very curious about what it is.
It's actually I actually attended a Halloween stuff with my friends who live abroad. So
Very
yeah,
cool.
that's thank you.
Right, best of luck.
Hi, is everybody here? And am I clearly audible?
Yes, you are audible, but your voice is a little muffled, very slow.
Was my voice better previously while timekeeping?
Yeah, but now I think it's better.
Okay, I'll just come closer to my device.
Yeah, now it's perfectly fine.
Cool. I hope both the teams are here. Are we good to go?
Yes, we are.
Opposition is
All right. I'll just set up my personal timer and start in a few seconds. So, hi everybody, and once again, congratulations to making it to the semi-finals of this tournament. I must acknowledge that that both the teams did really well in this round, and this was a high quality debate with a good level of engagement, right? So, I'll proceed with the feedback towards the end of which I'll reveal the verdict. So, as per the quality of the debate, this was pretty much an above average debate. The level of engagement was also nice, and the style of teams was also commendable, the style, manner, and content, which we'll discuss in detail right now. All right. So, what did I get from both the teams? Right. Side government comes and clarifies that one, we are talking about major crimes, trigger warning, crimes that look like mass killings, terrorism, rape cases, etc. And secondarily, they tell that this technology on their side, given that this is the policy motion and they do have the fiat to tell what the policy looks like, will have an access to the memory of the people with regards to the incident that happened and all the events that thereby occurred, right? With which they try to prove how system will be more efficient on their side, given that now you have solid evidence to know if and if not somebody committed the crime. But two, they also tried to tell how this will also improve the speed with which cases are tried in courts and thus solve the problem that we are talking about. Three, they also talked about how it's state's obligation to give justice to these people at the faster rate, and state is the one who will be sponsoring these machines even if they're expensive. And lastly, they also talk about how it's better for the victims, given that now they will not have to directly interact with somebody who's accused, given that this technology which can read mind of accused comes into picture. These are the major things I get from side government. What does side opposition talk about? Side opposition mainly tells us about how feelings of humans are something very important and something that they wish to preserve on their side. Apart from that, they tell that when these technologies come over, it's very likely these technologies might take over all the aspects in the future, which one makes people very skeptical of these technologies and people become mistrusted in these technologies, due to which, if such a policy comes about inside government, people are lesser likely to engage. But two, they talk about the right to privacy, which these accused people also have, and how it's bad to read something that's on their mind. Three, they question the very efficiency of this technology, that if this technology is foolproof, that it's vulnerable to hacking, but also the further mess it can create within the judicial system in terms of like certain inputs being read differently, even if somebody is aware they are seen as somebody guilty through this technology. But also when they talk about what if you have so many suspects and you actually get confused, what happens? So this summary of the debate that happened. Now I'll engage on what I felt was the engagement from both the sides on this issue. Starting with how side government responds to side opposition. On opposition's major claim on right to privacy, what side government comes and tells us that one, this right is not absolute, but also given that the person whose right is being infringed is somebody who has committed something that's a major crime, it's fair to infringe that right when that comes at the benefit of the victim getting the justice that they deserve. So they show an opportunity cost where the victim, who's somebody more vulnerable and somebody more in need of help, gets helped here, and somebody and the accused, who is somebody who actually needs to go to jail, is sent to jail. So they're talking about fairness indirectly, though they don't mention this word explicitly, right? So I think on that metric of where the vulnerable person is better off and where justice is better served, I think side government is able to mitigate the point of right to privacy on opposition. So I don't think the point of privacy on opposition thus stands. Secondarily, side opposition also brings about certain counter props in terms of alternative dispute resolution mechanisms, conciliation, mediation, etc. Right? How does side government respond to that? Side government tells me that one, these things are already existing in status quo but are still ineffective, which means the backlog is existing despite the very existence of these technologies. But two, something that we're talking about here is a major crime, and things like conciliation, mediation happening here between a person like the victim and whose family is immensely triggered by the situation and somebody who's the accused is lesser likely because victims won't necessarily want to interact with them. So here, the efficiency of alternate dispute resolution mechanisms becomes questionable, and I think thus I'm not able to exclusively credit these to side opposition. Then, when side opposition talks about, say, things like
what if witness is also aware and the witness is thus seen as somebody accused? I think this was clarified inside government's model when they tell that you are actually judging their memory. Either side, opposition could have questioned the very point on memory, like how exactly is judging memory, or memory is something which can be like hampered with somehow. Like if that was the case you ran, it would like it might have led a different outcome. But when you're saying that person is aware, somebody being aware and somebody having memory of a situation of what exactly happened, who exactly did that, are two different things. And I think side government was then talking about you you accessing that memory and not really the awareness. So when you see memory, you're also able to see who committed the crime, which makes it clear that somebody innocent won't be held guilty for the crime. So I think that point of side opposition was also mitigated with that. And with things like hacking, I think side government was able to weigh that when they told me that even if hacking is existing on site opposition where such technology does not exist, the evidence is easy to tamper with given that it's manual and rich people can easily tamper that, which means further poor and vulnerable sections being worse off that way. And lastly, when opposition talks about trust of people, I think side government tells that trust of people in judiciary is reducing already, given that judiciary is not able to clear cases at a faster pace. There's such a backlog, but also secondarily, given that there's corruption, there is biasness, tampering of manual evidence happening already. So when there's a technology that's at least marginally more foolproof, people are likely to trust. But even if not that, when government start using it for a longer time, trust of people comes with that. So I think side government was thus able to mitigate these points of opposition. But apart from that, they were able to prove increased efficiency and lesser backlog of cases on their side, but also victim not being as vulnerable in talking, because there are lesser situations in which victim will have to interact with the person right now. And all the other constructives that I mentioned in the beginning of my feedback, I think that's also stood. So because of these reasons, it's side government that takes over this debate over opposition. The motion stands. Congratulations, side government. You're making it to the finals of this tournament. But also, I think side opposition did a great job. But obviously, we have one winner in the round. And it's always an opportunity to learn from. So thank you. If there are any questions, they're most welcome. We can start with side opposition.
Can we get individual feedback?
Yes. I think we can move to the feedback once the questions and justifications are done. Any questions, side opposition? Side government one, I think government was Haryana, Team Haryana. Yes. Cool. No questions, side opposition. If you can convey that message to me with the yes.
No questions.
All right. Thank you. And all the best for all your future endeavors. Devika, are we supposed to give personal feedback on this meet itself? Or Anjali ma'am, if you're around? I'm not sure if personal feedback is something that can be given with everybody on the meet present. But if there are any case-wise feedbacks you need or overall feedbacks you need, you're most welcome for that right now.
So could we mail you regarding individual feedback? Because I remember last debate.
Yanshi, you can mail hello@ogly.ai. I'm just putting that email ID and we'll circle back with ma'am if you want more specific feedback. Does that work? Yeah.
That works.
All right. Thank you, everybody. Hoping to see you in future tournaments.
Congratulations to all of you. Have a good evening.
Thank you, ma'am.
Sure.
Thank you, ma'am.
Thank you, ma'am.
Yeah, sure. Devika, when is the next slot? The grade 7?
7:15. And I think Haryana won this one, right?
Yes, Haryana won this one.
Yeah, it's at 7:15. So ma'am can actually, Himanshu ma'am can actually go and join back in another 10 minutes.
Yeah. Sure.
All right, good.
Thanks, Himanshi.
Thank you.
You're just doing the message, right?
Yeah, I'm just doing the congrats message. दूसरे वाले room में कौन